Hello, Dig Nation. It's Stanfield Gray, your fearless host of Southpod, Rise of a Region. Southpod is the South's top tech podcast where executives, founders, funders, and ecosystem supporters explore what it takes to succeed in the South and beyond. Southpod is produced by Dig South Tech Media. The podcast is pre-recorded and captured in both video and audio. Southpod can be found wherever you download podcasts and is broadcast on Facebook Live and YouTube. New episodes are posted at digsouth.com. Learn more, sign up for our e-news, and keep up with the South's top tech news at digsouth.com. Now on with the show. Today we have an excellent Dig Nation member joining us on Southpod. Duncan Byers is an attorney and partner at Patton, Warnham, Hatton, and Diamonstein, headquartered in Newport News, Virginia. Duncan focuses his practice in all aspects of complex civil litigation and intellectual property, patent, trademark, trade secrets, and copyrights. Mr. Byers consults and litigates intellectual property and other complex matters for businesses and individuals in state and federal courts and in the United States Patent and Trademark Office. He is widely recognized by peers and was selected to Super Lawyers for 2014-2022. This selection is based off an evaluation of 12 indicators, including peer recognition and professional achievement in the legal practice. Welcome to Southpod, Duncan.
Good morning.
Good morning. Where does today's podcast find you physically?
I'm in my office in Newport News this morning.
Good. The last time we welcomed you as a guest, I believe it was prior to the pandemic. What's new in your world and with the firm? You know, how have things changed? How has that impacted you?
Well, we made it through the Delta variant pretty well. We locked down and did a lot of remote work. A lot of the partners are still working remotely primarily. They found it just as easy as working in the office. It's not 1950. We don't have to be in here with typewriters anymore. Mm-hmm. So we've done that. We're pretty well staffed back up again and have avoided mostly having any issues with the Omicron variant. We do require everybody in the firm to be fully vaccinated and boosted. So we take it very seriously. There has been some downturn in work, but it looks like it's coming back. I think a lot of people are figuring out how to work around the pandemic and trying to get out the other side.
Is that in the volume of work or the types of clients you're interacting with on a regular basis?
I think it's both the volume and the type. As you know, over the last few years, what's known, I guess, as gig culture has grown exponentially. A lot of people have left their jobs and have started doing entrepreneurial things on the side. So the inquiries that I've been getting from people like that have increased dramatically.
And have you had to, kind of think differently about referrals and how you attract clients and how you approach them, if it's via Zoom versus in person, or at this stage you've been doing it for several years, it's just natural?
I think it's natural at this point. Occasionally I have to meet a client face to face and there's just nothing I can do about it. And doing litigation, sometimes you have to do things in person. For example, I'll be in Orlando in 2 weeks in a deposition. And so I had to figure out the safest and best way to travel. I have an unvaccinated 3.5-year-old at home. So my exposure is her exposure. So I had to kind of twist it around. It's going to be a long day, but trying to be safe doing that. The other thing that it has impacted for me directly is in the litigation. A lot of courts shut down, no in-person hearings, and now there's a backlog of criminal matters, which, because of the constitutional requirement for speedy trial, those have to go on the docket first. So I've had a lot of civil matters pushed back. I've done a lot of mediations and hearings remotely, which it does impact it. It makes it harder, especially in mediations and settlement conferences, to actually accomplish something. It's better in person, but we're doing what we can.
Let's say I'm the founder of a new company or a fast growth startup. What are some of the things I should be concerned about from a patent, trademark, copyright standpoint, at the beginning? And maybe what's the best way to find the right attorney to represent me in those matters?
Well, first things first is documentation. One of the things that I run into with entrepreneurs and inventors is that they've developed something, or they're in the process of developing something, but they don't have a very clear record of the steps that they've taken along the way, right? How it was developed and dates that certain things were accomplished. And that's critically important for patent protection. It's also important for copyright protection as well. Trademark is a little different beast, but if you are, let's say, for example, you're starting up an online business, right? And you design a unique look on your website. Once that's published, you now have a clock ticking. In 3 months, you need to register that with the Copyright Office. Otherwise, you lose some statutory protections for statutory damages and attorney's fees and costs for infringement. On the patent side, it's important to realize when you have something that functions as an invention. It may not be the final form that you're looking for, but if you have something that actually functions, at least partly for the purpose that you're planning, that's the point in time to start thinking about getting some protection for it. In terms of patent attorneys and patent agents, to be clear, patent agents can represent people in front of the patent office and file patent applications for them. They are not attorneys, so they can't represent people in court. They can't advise and help with licensing and things like that. But in some cases, they're a more economic option if you can find the right patent agent. But finding the right patent agent and patent attorney can be important if you are in a very specific technology, say biotech. I'm not the guy you need, right? I have a bachelor's and master's degree in chemistry, but I don't do any biotech patents and never have. And so if I had somebody come to me, I would refer them to one of my colleagues who does specialize in that area. For general mechanical, electrical, and things like that, somebody like me is useful. I've done software applications, although most of those are now worthless, but that's a whole nother conversation.
Sure. So from a copyright standpoint, let's maybe switch gears for a minute with the advent of NFTs and the incredible volume of kids on TikTok and social platforms, and people just kind of grabbing songs and content and logos. It seems like the wild west of copyright at this point. How do you protect yourself? What should you be looking for?
It is. It's very, very difficult. Blockchain technology can help that, so that you can have copyrightable content that is protected and cannot be copied. That's critically important if you have something of value, but most people don't have. The overwhelming majority of content isn't protected in any way, shape, or form. It's just posted and there it is. Now, that doesn't mean that the creator doesn't have copyrights in it. They do. As soon as it's created, copyrights adhere to it and you can enforce them. But the problem is that the enforcement is expensive, right? So it's important for people that are creating content to think about that ahead of time, register what they're doing. I mean, if they're serious about it, especially if they're relying on it in part or in whole for income, they need to learn how to register that content for copyrights themselves, so that they've at least got the registration. And most of the time, if you've got the registration, you can stop infringers. But otherwise, it's just being vigilant. You can go to, especially if you have the registration, you can go to online service providers and have them take down material that you own the copyrights in. It's a process, but you can do it. But the biggest thing is to record those copyrights right out of the gate, preferably before you even publish.
So let's say the idea is very fresh, 7 to 10 days, 30 days. You haven't gotten around to doing that yet. Is it good enough to catalog something like that in a Google Doc that is time stamped, or email that concept to yourself? I mean, what's the fast, easy way to begin the process of kind of documenting what you're working on?
Right. If you're talking about content creation, the timestamps on the metadata itself will peg the date of creation. right? So somebody coming along afterwards doing the same thing doesn't have the copyrights in it. There can be innocent infringement, but you can still stop them from doing the same thing. And you don't have to register it immediately, right? As I mentioned before, you've got a 3-month window. But in my experience, a lot of content creators, especially because it moves so fast, right? I mean, there are content creators that are posting multiple videos on a daily basis. And so it moves very, very quickly. And they tend, if they put off filing for the registrations, they tend to let it slide. And then they find themselves 6 months down the road or 9 months down the road, and somebody has snatched some of their content in whole or in part, and they're sort of in limbo trying to enforce it because they really don't have the funds to go after them, but they don't have a copyright registration yet. So that's critically important. And most of the time, when people come to me for copyright registrations, I help them learn to do it themselves because it's very costly to pay me to do it. But once you learn how to do it yourself, you can do it in a short amount of time and for very little cost.
Excellent. And so let's say, you are, for example, a startup founder with very minimal budget and somebody does infringe your copyright. Is it wise to send your own cease and desist letter, or does that have to come from an attorney? I mean, how do you handle that?
Generally speaking, I mean, if you are on a limited budget, it's worth trying it yourself first, especially if you've got that copyright registration. And I would counsel people in general to get the registration before you do that, right? Because once the person gets it, especially if they go and seek their own counsel, then they're going to be told, yeah, you can't copy that. You've got to take it down. And they have a registration, which means now they can go into federal court after you, even if the copyright owner doesn't really have the resources to do it. There are some cases, and they're rare, but there are some cases where the theft of the content has caused enough damage and there's enough monetary value on the backside that somebody like me might consider it either on a split fee basis or a flat fee plus a percentage of what the recovery is, or on a straight contingency fee basis. But those are rare, especially in online content, because there's not a lot of money for each TikTok post, right? But in the aggregate, there is. The problem is that unless somebody takes the aggregate of what you've posted, then there's really not much value in any one individual post. So again, getting the registrations is important. And yes, trying a cease and desist yourself first is also important. Once you get attorneys involved, it gets very expensive very quickly.
Yeah, I had a relative who worked for a large media organization, and they actually had a budget set aside in case they accidentally infringed on someone's copyright. And they would say, our mistake. How about $5,000 or something? They would just kind of. Is that something common that you've seen? Like, let's say it's CNN or NBC or someone like that.
Yes, absolutely, and that's something that people that are doing startups need to consider as well, because at some point they are going to need to defend themselves. One of the things that I see all the time is there's an entire industry out there of people whose content, photographs and writings and the like are not very good or not very popular. And so they're not making any money off of them. And what they do is they sign on with law firms, and I'm not going to name any of them, but there are law firms out there that do this, that will take these things in bulk and post the content with a license agreement that says, hey, you can take this for free, but if you're going to take it for free, you have to give attribution of where it came from. But they do that in very small print. They hide it. It's there, but they hide it so that people come along, website developers or just normal everyday people who have their own websites for families or whatever. They see a poem that they like, they see a photograph that they like, and it says, hey, you can have this for free. And they don't read the fine print. Next thing they know, they get a letter from one of these firms demanding $3,500 or they'll be sued, right? So it's a trap for the unwary. So for anybody out there that's getting any kind of content off of the internet in any way, shape, or form, they need to make sure that they pay attention to those license agreements, because they are enforceable even if the content is free. And it's a huge business, and I fight against those guys all the time.
Are there any rules regarding how the attribution is placed or the size of the typeface or anything like that?
That should be in the content of the license itself, right? So whoever's getting content needs to read the license agreement, because most of them say, you have to post it in a font that's a certain percentage of the image, size of the image. It has to be posted prominently below the image or embedded in the image. Some of them have different rules and regulations on it. But if the license agreement simply says you must give attribution, then somebody should generally just default to, let's say it's a photograph, putting the attribution in big enough letters that there's no question where the content came from, so that anybody looking at the image right underneath of it can see where they got the image and who has the rights in it.
Hey there, Dig Nation. It's Stanfield Gray here with big news. The 10th anniversary of Dig South Tech Summit is coming this May 11th through the 13th to the College of Charleston TD Arena. Check out details at digsummit.com. Think emerging technology, scalable business, digital marketing, fintech, Web3, crypto, NFTs, health tech, and much more. Come check it out. Meet innovators, entrepreneurs, executives, founders, and other leaders in the tech space. Have a blast in Charleston. It's beautiful in May. Come check it out at digsummit.com. That's digsummit.com. Now, back to Southpod.
What are some other common mistakes founders make outside of the copyright in early stages of company formation? Relative to your practice, of course, but maybe some other tips you've just noticed along the way.
Well, when it comes to startups that are developing patentable technology, whatever it is, right? One of the common mistakes that I see, especially when you have tech companies that require manufacturing support, whether it's silicone chips, or whether it's having somebody actually in a foundry creating a mold for you or the like. One of the biggest mistakes that I see is that the startups will engage manufacturers, but not bind them to agreements to keep the information confidential, right? The second problem with that is that once the information is out in the public, and a lot of people want to go out and they want to, give talks, they're obviously trying to get investors, right? So what they'll do is they'll go and they'll give presentations. I mean, that's what Dig South does all the time, right? So once you've shown to the public what you're doing in the United States, you now have 1 year to file for a patent application. If you do not, you've lost the ability to patent it, and it belongs to the world. So,
wow. Okay.
Yeah. Mm-hmm. So confidentiality agreements with any partners that you're working with, whoever they are, whether it's financing, whether it's manufacturing, whether it's bringing in website developers, if you're bringing in, say, programmers, you need to make sure you have agreements with them, along with, if somebody's creating content for you, having agreements that say specifically that it's a work for hire, so that they don't have the rights in the content and can take it from you and can copy it themselves, because you're paying them to create it. So these agreements and these steps are critically important, especially in the patent arena, because you can lose your rights in it once it gets into the public domain.
Well, a lot of investors, especially some of the larger VC groups, because so much information is presented them, so many pitches, they won't sign NDAs. Is that just a roll of the dice for you if you're that kind of company that feels like you have some important, trademark information that can be trademarked, or something or process that can be patented?
Well, I to be honest with you, I find that practice very unprofessional. If you're serious about getting into the tech arena, and you're serious about investing in it, number one, you will vet what people are trying to pitch you before, to get an idea of what the technology area is, how far along they are. is it worth taking a look at it? And if it is worth taking a look at it and worth considering putting your money into it, then it's worth getting into an NDA with whoever's doing the development. I have counseled clients before to walk away from people who were suggesting that they would fund them, but would refuse to sign NDAs because it's like I said, it's very unprofessional, and the NDAs protect everybody. So, you know, I understand I understand the hesitation because you know, especially you know, investors will come in and they may fund a lot of technology, but in the process, they may fund technology that could potentially infringe other technology that they've invested in. And so they need to be very cautious as well, right? We counsel investors as well with regards to these issues. So they need to be careful as well. But again, the non-disclosure agreements and similar agreements protect both sides. And so I'm very wary of people who will not sign non-disclosure agreements. Now, I mean, I know people get pitched widgets, right? Somebody thinks they've invented something and they really haven't. But again, that goes to doing your vetting. Asking them, don't tell me specifically what you're doing, but what area is it in, right? Is it, you know, something that college kids are going to use to shotgun beer? Maybe that's not something that, number one, is protectable, or number two, is something that I want to put my money in, right? But if it sounds like it's a serious advancement in one particular field or art, then it's worth signing an NDA to find out exactly what it is.
So, you know, how is the law profession itself being impacted positively or negatively by technology such as automation, blockchain, you know, some things you're seeing, and are there opportunities there for attorneys that may be tuning in?
There are a lot of law firms and attorneys have leveraged the technology to be able to make their personal life far more flexible, right? So, for example, it is, at least in Virginia, and it can vary from jurisdiction to jurisdiction, but in Virginia, it is permissible for somebody to actually live and work in Virginia as a lawyer, even if they're not an attorney that's licensed in Virginia, as long as they're only practicing the law in the jurisdiction that they're actually licensed in, right? So you could have somebody who is licensed in Maryland, lives across the Potomac in Virginia, and is working for and with Maryland clients, applying Maryland law, and they don't run afoul of any ethics problems. That didn't used to be the case. A lot of jurisdictions would actually require you to have a physical presence in the jurisdiction. And so a lot of that with the technology, you know, the ability to move everything into the cloud as opposed to, you know, hard copies and killing trees, right? Or keeping it on your own local server. That's allowed us to be a lot more flexible, and quite frankly, has freed a lot of us up to have a much healthier and happier personal life.
Sure. Has that sort of expedited the franchise model, so to speak, or do you see more consolidation among law practices due to some of these innovations?
There is consolidation. I've seen, you know, larger law firms that have just associated with or brought in other law firms that are already established in another location. And essentially they just change their name and bring them into the fold and whatever their financial structure is and the like. But the technology allows that to happen very quickly, right? Instead of going and having to establish a brick and mortar, you can talk to smaller firms or boutique practice groups and bring them into the fold. But it also means that a lot of law firms are getting smaller and streamlining, right? So instead of having for every one attorney, you have, you know, 2 or 3 paralegals and 2 or 3 associates and 2 or 3 assistants. It's been streamlined a lot. We run fairly cleanly here. I have 1 assistant. We do have a couple of associates, but most of my partners have 1 assistant and do most of their drafting and the like. Where it used to be, you know, the old day was, you know, the partners would dictate into a dictaphone. And in the big firms, you have this huge bank of recordings and a group of people, mostly women at the time, who would do nothing but transcribe what was on the dictaphones. And those days are obviously long, long gone. So it's allowed us to reduce overhead dramatically, which helps the client, because I don't have to charge $1,000 an hour, right?
Yeah, right.
So
you don't have to hire a film crew. You could do it on Zoom and record it.
That's exactly right.
Yeah.
There's still some things that are extremely expensive. And one of the downsides to the last few decades of advancements in technology is electronic discovery. Electronic discovery, because content is created so fast, right, that you end up having to spend a lot of time and a lot of money getting experts to come in and gather the information, store it, right, protect it, and search it so you can find what you're looking for. I'm working on a case right now where I had a laptop that was imaged and backed up. And when we did the search on it for the content I was looking for, I ended up with 250,000 images alone.
Sure.
So
yeah, I know some graphic designers that easily have that many images collected, probably.
Right. And the number of emails and the like. Now I'll leverage software to make it easier on my end. For example, with emails, I just convert everything to searchable PDF, right? That way I can dive into it, but you're still talking about tens of thousands of pages that you have to go through. So electronic discovery can be pretty daunting, and the courts, especially the federal courts, have actually taken steps to limit the scope of it so that you're not demanding that the other side produce 10 million documents, right, just based on this really broad discovery request. So it has changed how we litigate.
Okay. So what can the Dig Nation community help you with, and as we ramp up to the 10th anniversary of Dig South Tech Summit, what are some of your needs, or what are things you'd like to share with the community as well?
Well, one of the things I can tell you is, and we've been in the process of moving everything off of our local servers and into the cloud, right? Mm-hmm. Anybody that can assist law firms to make that transition smooth, when you're talking about millions of documents. I mean, our firm has been around for a very long time, and so there are a large number of documents that need to be migrated. And the other thing is that there are a number of integrated law practice suites out there, but none of them do everything, right?
Right.
So so a lot of them don't pay attention to the financial side of it. And we've been running software and for a long time that didn't allow for clients to make online payments. Now we've rectified that, but we're having to integrate bits and pieces together in order to make it work. And so if somebody wants to make $1 billion, talk to me and work with me on making an integrated suite that works for pretty much every attorney and does everything that we need it to do.
So what will be some of those different divisions of the firm you would integrate? Like the financial side, obviously.
Right. In a perfect world, I would have one interface that takes me to document control and creation, messaging, both with myself, between members of the office and with clients and with other people outside of the firm, along with financial control, time, and billing in it as well. If you can bring all of those together, then you've got something. And I've been pitched any number of them saying that it's a perfect solution, and none of them are, right? I'm not going to tell you what we've been using, but it's been a nightmare trying to figure out how to integrate into something as simple as QuickBooks, right? QuickBooks has been around for decades now. There's no reason in my mind why you can't integrate into QuickBooks, and yet we find that it's incredibly difficult with a lot of the software that's out there. So an integrated solution that is also extremely robust in terms of security is critically important, because we are, and this is a discussion that the bars have been having for a long time, putting documents into the cloud, because that is confidential client information. And so, having a really robust security backup on it is critically important for that. So that's my wish list.
I know some people who probably love to tackle that and think it through. Now, whether they can map out the actual solution that's affordable, who knows, right?
Yeah, affordability is relative, right?
Right.
I mean,
that's a good point.
As a practical matter, if somebody actually comes up with a structure that allows it to integrate with QuickBooks, Outlook, the document control and creation and the like, then law firms will pay a pretty penny for that kind of package. And there's lots of them out there, but they all do things differently and they don't integrate. So
I understand. So how can our listeners get in touch with you? What's the best way to reach out?
I can be reached by email at dbyers, that's DBYERS, at pwhd.com, Papa Whiskey Hotel Delta.com. I'm more than happy to pick up the phone. I can be reached at my direct line, which is 757-223-4474. If you want to look at me before you talk to me, if you go to pwhd.com and click on the attorneys link, you can find my bio there. I can also be found on LinkedIn. I communicate with a lot of people on LinkedIn. I can also, it's 2021, I can also be found on WhatsApp. I do not have a Twitter account, but email and LinkedIn are the two primary ways that people can get a hold of me.
Excellent. Well, today is Groundhog Day. So for my last question, I'm going to frame it around that. If you had one professional do-over throughout your career, or let's say you could advise your 24-year-old, 25-year-old self, on that path, what nugget of wisdom would you drop on them, or what would you do a little differently in just one career situation?
I don't know. That's an interesting question. I've worn a whole lot of different hats in my life, right? I was a firefighter, an EMT. I was in the Navy. I did a bachelor's and master's degree in chemistry before I went to law school. I was a commercial and industrial electrician. So I've done a bunch of different stuff. I don't know. I think I probably would counsel my younger self to figure it out earlier and decide on what the path is going to be, as opposed to bouncing around. Although, to be honest with you, a lot of those things have helped me in my law career, right? I speak a lot of different languages, not in terms of, actual different languages, but in terms of different careers and trades and the like. I can sit down with somebody that is a blue collar worker and get very quickly into their mindset and what they're doing and what they're developing. I can work with, researchers and other developers. So I'd probably tell myself to stop bouncing around so much with some of the stuff that's not as important. But other than that, I've had a pretty good life, I think.
Fantastic. Well, Duncan Byers, thank you for joining us today on Southpod.
Absolutely. It's been my pleasure to do this again. Hope to talk to you soon.
Thank you for joining us today on Southpod, Rise of a Region. Southpod, the first and foremost podcast created to tell the story of tech innovation in the American South. Southpod is hosted by yours truly, Stanfield Gray, and produced by Dig South Tech Media. Visit digsouth.com for details and join our membership group at dignation.co. And don't forget, join Dig Nation today and grab your free badge to Dig South Tech Summit, where leading brands meet the smartest, most scalable startups. Dig South Tech Summit will be held May 11th through the 13th in beautiful Charleston, South Carolina, at the College of Charleston TD Arena. Visit digsouthtechsummit.com to check out speakers, sponsors, and other details. Till next time, I'm Stanfield Gray, your host of Southpod, Rise of a Region. Thank you for joining us.